Hello, welcome once again to the Law Professor channel. In today's presentation, we shall be looking at a very important aspect of family law, and this relates to the question of settling property disputes between spouses, especially at the time that the marriage has disintegrated and there is the need to determine who owns what. In this context, the law is determined by the legal framework in each jurisdiction. And we are familiar with the fact that in Nigeria, the family law system is a plural legal system, which means that the laws that will regulate a marriage depends upon the system in which the marriage is celebrated, whether it is the statutory system, whether it is the customary system, whether it is the English, the Islamic law system. So in today's presentation, we shall essentially be looking at uh, how the law looks at parties and their rights to property when the marriage has broken down. This presentation therefore focuses on claiming rights to property as beneficial owner. You are not coming before the court to say that the law should do something in his discretion, so to say, but you are claiming a legal right to particular assets or property acquired by either or both parties when the marriage was in existence. As usual, we'll be using um, slide presentation. So I would proceed to share um, my screen. And as we as we sorry, let me just take that um, slide to the right place. In previous presentations, we've looked at some property issues, but today we are looking at it strictly in the context of when there is a claim as of right, a claim of ownership between the husband and the wife towards a particular property. So our learning outcomes are threefold today: to be able to understand the context in which the law or property rights becomes relevant. At what point? Why do we even need to determine who owns what between the husband and the wife? We'd also need to understand the various marital property regimes that are in place, just a general understanding of what the law generally says about marriage and property, and then understand the position of Nigerian law with regards to marital property rights and marital property regimes. The need to situate property rights. Why do we need to know uh, particular property rights? Who owns what? Because like I said, what this is about is to say, for instance, who owns the television sets? Who owns this? Who owns the car? The house, the matrimonial home belongs to who? Is it to two parties or to one of them? We all know that in most societies, when marriage takes place, the understanding is usually that they come together as partners, they work towards a common interest, parties are together, and they intend to be together for life. But invariably, sometimes some marriages will disintegrate. But it's not only in the context of disintegration of the marriage that you need to know the issue of who owns which particular property in marriage. So in this presentation, we have outlined four reasons why we need to situate property rights, why you need to determine who is the owner of particular assets in marriage. One is to redistribute the property on divorce that I have emphasized so far, to actually know when the marriage has ended. You need to determine who gets what. They are not going to be husband and wife again. They are not living together again. So in the past, when it did not really matter who bought the fridge, who bought the car, who bought the land, now like a business interest that has disintegrated, and you need to share, to determine the rights of partners. So in a marriage that has broken down, it becomes imperative to know who owns what in the eyes of the law, in the eyes of the law, not by emotional attachment, not by anything. So in order to know how to redistribute these properties upon the failure of the marriage, you need to know who owns what. You also need to protect the estates and interests of third parties, like creditors and mortgages, mortgagors with claims against a spouse. What do we mean by that? If somebody, for instance, has loaned money to the husband, and he has mortgaged the house that they are living in as belonging to himself, when in actual fact it is a joint property, the wife did not obtain the loan. So the husband is the actual debtor. So if the creditor, maybe a bank, for instance, is unaware that that house does not belong to the husband, and he goes ahead to provide it as security for a loan, that bank will not be able to levy execution against the interest of the other spouse. That means that they might have obtained in perfect security. Their security interest is not is not a perfect one, because the husband does not have the power to give out the property as a mortgage when it is not in his exclusive legal interest. So to protect creditors and mortgagors, for instance, and mortgagees rather, it becomes imperative that so that when someone wants to bring and say, okay, I want to use my car to stand, I want you to have a lien on my car, or for this money you are giving me, whatever, you are able to determine, is it really his car or the one that belongs to his wife, and what have you. So then, thirdly, to safeguard the interest of the other spouse against alienation. Again, just on the other side of the device of the last point is the fact that in case, for instance, a wife tries to sell the property, which actually belongs to herself and her husband, how would the law protect the interest of the husband if it does not determine who actually has the legal title to that property? So these are the reasons why, despite the fact that marriage brings people together and they are regarded as one in the eyes of the law, when it comes to property rights, there are situations and circumstances where the law must determine what laws would apply to their property interest. Then another aspect of it is the fact that you need to know who actually owns a particular property because of inheritance, for instance. As husband and wife, nobody really knows who is putting money down for A or B or C. And someone might decide, for instance, to write a will and will out a property that belongs to the spouse to a third party. That will not be acceptable in law. So it is also imperative so that others who may be having expectations of inheritance might not be misled. And then when one spouse is gone, you have litigation because someone somewhere says, oh, this is my father's asset. And even though you're not my and even though you're my father's wife, then I think I have a claim to this asset, when in actual fact, the asset belongs to the wife. So these are some of the reasons why you need to situate property rights. Now, in what ways do people make claims? Usually in the context of family law, the assertions, when a marriage is coming to an end, especially there's a divorce case, a lot of the times you have spouses that would assert that they are the owners of a particular property. And the other spouse would still also assert that he or she is the owner. So you have these disputes occurring, and sometimes the spouse will claim that he has made direct financial contributions to the acquisition, development, or maintenance of the property. So you have this property. Now, let's understand this premise. In property law, in Title, let us take land. It is determined in Nigeria by the person whose name is on the title deed. For example, let's take a certificate of occupancy, which is in the name of the husband, demonstrating that this property, the right of occupancy, resides in the husband. Now, the marriage is coming to an end, and the wife comes out and asserts that, well, although this certificate of occupancy is in the name of my husband. I also contributed to the acquisition. When he paid 10 million for that house, 5 million of it belonged to me. I gave him 5 million. Now, in a typical marital relationship, there may be no documentary evidence of these payments. There may be no written agreements. Usually, there's no written agreement in such cases. There's nothing to show what happened except the testimony of the husband and wife as to what took place between themselves. So she might claim that she made direct financial contribution. She paid some money to the husband. In fact, sometimes the wife may claim that she actually paid the entire 10 million, for example, or she paid 8 or whatever. When the man was going to pay for the land or towards the development of the house or the land or the maintenance of the property. Then she may say she didn't pay for the land, but she was the one that bought all the fixtures, the windows, the whatever, during the building of the house. So you have claims like that. Although the name of the wife is not on the title deed, it's not on the certificate of occupancy. Or you might have situations where they will have sat that the claiming spouse will assert that he or she made non-financial contributions to the property. You have situations where the husband, for instance, is working and so the wife not to work, or the wife decides not to work, and she's been supporting the home in terms of maybe taking care of everything, take care of the children, cooking, the typical domestic chores. And she feels that now that the marriage has ended and this man has 10 assets, everything is in his name because she has made contributions to the non-financial contributions to the property or to the marriage, or she might have said that when they were building the house, she was the one that was using her money, she was feeding the laborers, she was doing A or B. So you have situations like that she asserts that she has made non-financial contribution to the property, or the spouse made contributions. She may assert, or he may assert that she has contributed to the life of the husband in the sense that maybe both of them, for instance, are working and or maybe the wife is not working, or the wife is, let's just take example of the wife is working, the husband is not working, or is going to school, or is for further his education for the 5 years of the marriage. Maybe he's trying to obtain a master's and a PhD, and the wife has taken on the responsibilities of the marriage completely. She pays the house rent, she buys the fuel, she feeds the family, she pays the school fees. She practically does everything that the husband and wife are supposed to come together and jointly do, so that the husband has a better degree, a better opportunity in life. Maybe, or the wife, or it can be the other way that he has educated the wife all the time they were married and now she wants to divorce him, or he wants to. So you have situations like this. In all these cases, so the other spouse is saying, well, despite that all these properties are in your name, because I was the one that made these contributions to your life. If I didn't make these contributions and I was using my money to also acquire assets, I also would have some assets in my name. So in this context, therefore, I should also be equally entitled beneficially. In this kind of cases, the spouse, the claiming spouse, is not saying that the law should be use its discretion to do justice, like the situations we have, for instance, under Section 70 of the Matrimonial Causes Act, when it deals with maintenance. The person is coming as of right, as making a legal claim to say that, look, in law, I am the beneficial owner of this property, either alone, because the 10 million for this property was my 10 million. So I'm the exclusive owner, or they are claiming that they are joint owners of this property, that we should share it maybe 50-50, 60-40, or whatever percentage they assess to be the ideal percentage based on their contributions. So these are some of the contexts in which disputes may arise. Now, what is the law? The law that regulates this kind of situation is what we are describing as marital property regime, a system that addresses property rights between husband and wife and says, look, this is the way, despite in the light of your marriage, this is the way your property should rights exist in the eyes of the law. Now, when people get married, it is common to say, for instance, in the English kind of marriage, that, oh, for better, for worse, for richer, for poorer. Sometimes people say, oh, uh, with all my worldly possessions, I did well. with all my body, I did well. With all my worldly possessions, I did well. I did well. Tribe was therefore saying that, look, I've joined my property with your property, I've joined my life with your life, I've joined my assets with your assets. So, what is the legal implication of this in law? Does it really translate to the fact that you have joined your property rights such that not everything belongs to you in community? So, if a marital property system is a system that tries to tell us the law regarding the property rights of married couples, and it deals with laws that establish their rights or alters their rights by virtue of marriage or terminate their rights in any system, in any society. So it determines the rights of the parties to assets acquired by either or both of them. So this marital property system tells us, so now that you are married, what is the implication of marriage on your property? What you had before the marriage, what you had after the marriage, during the marriage. When the marriage is coming to an end, what is the property, what is the legal framework for sharing your property? What rights do you have in each other's property? Does marriage make your property joint, or does it make it exclusive? Now, in globally, there are 4 common types of property regimes globally. There can also be variations, but the common types are globally are what we call the partial community of property. In this kind of property, the property um the community of property system vests property that is acquired before marriage on the acquirers as separate property, but post-nuptial properties are regarded as joint property. So if Mr. and Mrs. A had each of them before they got married, any property that belongs to either remains their individual and separate property. It remains their separate property that they can do anything to it. Even when they are divorcing, you cannot take that property and give to the next person. The property belongs to each person. They are prenuptial property. But any property that they acquired from the point that they got married becomes joint property. It doesn't matter who puts the money down, but it doesn't matter how the property was acquired. It becomes community of property. That is, it becomes common property between the husband and wife. But the ones they had before marriage, maybe the husband had 10 houses, the wife was given 5 by her father, she bought 2, all those ones remain their individual property. It cannot be touched by the law during the divorce of the parties. In full community of property, all prenuptial assets of each party and postnuptial assets become joint property immediately upon marriage. Once they get married, everything they've had in life becomes joint property. And when the marriage comes to an end, in such systems, the property will be shared equally between the parties. Irrespective of how the property was acquired, it is shared between the parties as joint properties. And that's why you have in some jurisdictions, you will see that divorce is a major issue. And it seems like some countries, in fact, they call them divorce capital of the world, because, and in such systems, it will seem that marriage is favorable to women, because once marriage has come to an end, then the property is shared 50-50, so to say. Then in a system that has partial community of property or full community of property, the law will demand that title deeds are jointly titled. Joint titling is required. So, for instance, if in such a system they use the certificate of occupancy with respect to landed property, the C of O must reflect the name of a husband and wife once you are married. It is mandatory, so that any creditor, for instance, will be able to see that this is marital property. And so they will know whether they want to give you a personal loan using marital property as security for that loan. Then you have deferred full or partial community. In a deferred full or partial community, it's the same rules of full community or partial community, but these rules are suspended till the point of dissolution. It's only at the point of dissolution that they become operative. So deferred full community is such that when the marriage is coming to an end, whatever is left in the marriage at the time the marriage is coming to an end, that is the one that is available for sharing. And then when it is partial community, the same thing. It's just that it is not going to start operating until the marriage comes to an end. In the earlier ones of full or partial, the systems begin to operate upon marriage. they begin to operate upon marriage. In a full community, for instance, or partial community that is not deferred, whatever you are dealing with in the marital asset is a joint dealing, so to say. But in deferred one, it's only up pick up. So you can actually have your separate property regime, your personal interest, doing everything that you like, as long as the marriage is not disintegrated. But once there is divorce taking place or nullity, the community or property system becomes operational. The last one is the separate property regime. In such a system, marriage has no implication on your property rights. You come the way you are and you go the way you are. Nothing changes about your property. Even though in your interactions as husband and wife, the couple, the couple believe that they are joint owners. You know, you do everything together. Everybody uses the family car. You take one car today, the other one takes another car tomorrow. When you build the house, you think that, okay, we have built our house. And the wife tells all her friends, we are moving to our house and whatever. But if their house is in the name of the husband alone, that property, legally speaking, remains the property of the husband during the marriage. So in a separate property regime, each person has a separate ownership. Anything that they buy with their money remains their individual property. It doesn't become joint property of the marriage. It doesn't become marital property. So parties retain individual ownership as marriage does not impart property rights. And by default, this is the regime that operates in Nigeria. When a couple gets married, it doesn't mean that property becomes joint property automatically, unless you make it joint property, maybe by an agreement, any other legal framework. Now, the marital property regime in Nigeria, like I said, is separate property. And what it means is that ownership remains individualistic. If I buy a car today, it remains my car. It doesn't become, because as long as I put only my name on that car, it remains my car. If the husband builds a business or a house in his name, it remains his individual property. And marriage does not give an automatic right to the other spouse in that asset. Marriage does not give an automatic right to the other spouse in that asset. Okay, so it is a strict property law regime. When it says strict property law regime, it follows when anything is happening between the couple, the provisions of the law of property would apply. How you determine ownership of particular property would apply. If it is landed property, then you know that you must agree. I mean, you cannot transfer anything by other agreements anyway in Nigeria. So how does the property law situate their rights if you are if you have a separate property regime? Whatever property law says applies to the parties. So it is a strict property law regime, and in that regime, the law is asking who is the owner of this property. That's what a strict property law regime talks about. Who is the owner of this property? In a typical family law dispute, you are trying to say, who should we give this property to? In the interest of the way marriage works. Marriage, you don't actually put your eyes to law, to dispute. You believe that the marriage will be for better, for worse. I mean, you believe that it will last the lifetime of the parties. And so you don't really put your eyes to litigation as you would do in a commercial contract. The way you would say, oh, let me look at the agreement very well. Is it in my interest? What if this happened? What if that happened? That does not really happen in marriage. Although legal systems recognize prenuptial or postnuptial agreements based on the kind of legal system that you are working with, okay. But generally, the parties in a marriage are not as litigation conscious, law conscious as you would you would see in a commercial transaction, especially in a country like Nigeria. So it's a strict property regime which asks who is the owner, and the ownership is in black and white. Whose name is on the title deed? Whoever's name is on the title deed is the legal owner, prima facie. Prima facie. There are other rules of engagement that we'll be looking at in subsequent presentations that may affect that. Then in this regime, that is a separate property regime, it requires that if you are going to get any interest in any property, you must be able to prove to us that you made direct financial contribution to that property. you must prove it to the court. The court will not take any other evidence beyond that direct financial. You must be able to say that, yes, this house is the title deed of this house is in the name of Mr. X. So property law says, because the C of O, the certificate of occupancy is in the name of Mr. X, Mr. X is the owner of this property. Now, Mr. X and Mrs. X are getting a divorce. And Mrs. X says, no, although the name of Mr. X is the only name on that certificate of occupancy, I am a beneficial owner, I am a joint owner, or I'm the real owner. It depends on the context in which the argument is taking place. I am entitled by law to that property. In that case, the law will require, street property law will require that you make if she establishes a direct financial contribution, for instance, how she transferred the 8 million for the property to her husband, who used that 8 million to buy the house. So that's what we mean by direct financial contribution. So in that regime, non-financial contribution that is saying, oh, I was one that was supporting him at home by doing every other chore in the house, that's why I was able to acquire the property. Those considerations would not matter. The disadvantage of this regime is that, in fact, it has many. It could lead to injustice because in such situations, Mrs. X may not be able to prove it. She gave the money to the husband. Thank God, okay, in this generation that we have, can do bank transfers. But what if she gave cash and nobody is there to witness it? They did not write anything down. In a typical marriage, you will not write down and say, today I'm giving you this 8 million towards purchase of, in a typical marriage. That is not to say that you will not have situations where that could exist. But the law requires that she establishes it. So there could be injustice. So sometimes you find that that regime, it does not take cognizance of the way marriage is organized. And you might find out that, especially with regards to women, a lot of them would have spent 20, 30, 40 years in that marriage, supporting the union, supporting the husband, supporting the home, supporting the children, and not being able to acquire anything for themselves with any resources that they have. But the law says that they have no interest in the property. And so they will lose out of such cases. So you have cases in Nigeria which have determined this. One year, where the court asked for proof of contribution. The wife was unable to provide it, and the court said he must be able to provide it. The court is not a Father Christmas where you just get anything free of charge. So you have Amadi and Iwosu. In this case, the husband had sold the house and the wife refused to leave the house. So the purchaser had to bring the case to claim, trespass to land, and asking that the wife should be, she move out of the house. But the wife claimed that she contributed to the house, its development, to the purchase of the land, and to the building. She said she paid for labor, she paid for sand when they were, developing the house, and all these kinds of oral evidence. But the court said no, there was no evidence to establish her claim. There was no witness to support what she was saying, and that they had to take the evidence of the husband who had the title deed in his name to show that he was the owner of the property. You also have this statement by the Supreme Court in Namadi and Usu, saying the applicant argued that she contributed to the building of the house. If it were so, then certainly when she came to testify in court, she ought to have explained the quality and quantity of her contribution. So she must tell the court what she did and the quantity. Maybe it's money, how much she paid at what occasion, and bring the evidence. She ought to have given details and particulars of the contributions which would have enabled the court to decide whether or not she owned the property with her husband. She did not. In addition, the appellant called no witnesses to prove that she contributed either labor or sand to the building. Now, we all know how marriage is. Most times, nobody is there when the husband and wife are discussing and making plans. And because of that, she lost out. Then you have these other cases too, Adetule and Adetule, Akimboni and Akimboni, where the court insisted that for you to disprove title in a title deed, you cannot use oral evidence. You cannot come to court and just tell us that, hey, we agreed, my husband and I agreed that the house will belong to the two of us, or we agreed that I should pay 5 million out of the 6 million, and that he will purchase the property and it will be in our joint names. Conventional route of title must be established. The way normally you establish title to land, you must establish it. And be unable to do this and bringing oral evidence of what transpired in marriage has always been insufficient and unable to protect the property interest of the disadvantaged spouse. And typically, they are women. You have Adiromu and Adiromu again, which rejected oral testimony. And you have Muela and Muela, where the court uh, was did equal division of the property because number one, both parties agreed uh, that the property, they contributed to the property, and the property was in the name of both parties. And the court said that if the property was in the name of both parties, then they will share it equally, and that equality is equity. And they try to find that equality in the way they allocated the property between the two parties. So the case of SN and SN, in which the wife was trying to make a claim for indirect financial contributions. That is, when you say indirect financial contributions, the contribution was not towards the particular property that they are fighting over, but saying that, look, I made financial contributions to the marriage, to the needs of the family, to the children's life, to the husband's life. I used to give his mother money. I used to give his siblings money. I used to pay for the food while he pays for the school fees. And that because of that, contributions to the marriage, to the family needs, those financial contributions are indirect contributions to the acquisition of the assets that the husband has acquired. And the court said that such indirect contributions are ineffectual in a strict property law regime in granting an interest, even if you want to base on trust or on a resulting or constructive trust, that it was ineffectual. And they relied on the English cases of Gissing and Gissing and Riemann against Riemann. In both cases, the spouses that were claiming an interest were not named in the title deed, but they were asserting beneficial interest. A beneficial interest, like I said earlier, is an absolute interest, is a claim of ownership, and they were relying on trust concept for this purpose. And the House of Laws in those cases also denied these claims, that they must establish, the parties must establish a common intention that these houses be held, on trust, before they can get a claim. We shall be looking at that in more detail at subsequent presentations. So, Essen has says another aspect. So now we have that Swiss property law position, but there are other ways, like I just mentioned, where you can use the courts have had to examine the rights of a husband and wife. And one way is to look at the question of Section 17 of the Married Men Property Act, to look at resulting or consultative trust, or to look at the concept of matrimonial homes rights, settlement of property, and other vehicles that the law may make available for parties to have an interest in their in the marital property. In conclusion, therefore, we could say that in each society there is a marital property system. Sometimes it is written, sometimes it is not written. In Nigeria, um, there is no marital property system that the law has provided. So we normally say that by default, it has a separate property regime. A marital property regime is the legal framework for property between married couples, particularly when the marriage breaks down. Particularly when marriage breaks down. And there are four common types globally: the partial community, the full community, the deferred full or partial community property, and separate property regime. Nigeria does not have any laws that says that when you get married, these are the implications of marriage. There are no direct law. There's no direct framework for that. We have some snippets of legal implications of property on marriage, like when there's a divorce under the Matrimonial Causes Act, you can say you can settle property on the other spouse. You can look at the laws of maintenance, but these are not claims out of rights. They are not beneficial ownership claims to property. So by default, Nigeria operates a separate property regime, which marriage has no implication on the property rights of married couples. Any claim to property rights must be established by strict rules of property law. And again, I said we'll be looking at other vehicles that we can use to settle property disputes in marriage in order to claim that beneficial ownership or to get some interest in the other spouse's uh, uh, property. So, be that as it may, these are some of the issues when it comes to disputes regarding property between couples, especially when the marriage has disintegrated. But we have said that there are other reasons why we should understand this aspect of the law towards a better and a more developmental approach to the law of property between marriage couples. In the subsequent presentations, we shall be looking at other aspects of marital disputes and how the law uses other vehicles to address this, especially the vehicles that we have mentioned in this presentation. Don't forget what I said earlier, that what you are looking at in this case is the claim as of right, that the wife or the husband is saying, I am the owner of this property that is in my husband's name, or we are joint owners of this property that is in the name of the wife alone or the name of the husband alone. Either whatever the reasons for such claims, maybe because marriage has broken down, maybe because somebody wants to execution, maybe because somebody has used that property as a judgment, as a debt, whatever may be the basis for the claim, it is usually the case that you must establish who is the owner of the property in the eyes of the law, not in the emotions or of the parties or whatever. So thank you for listening. I'll see you at the next presentation.